In this podcast, we start to talk about the nature of consideration. I think Corbin said it best when he said, "The mere fact that one man promises something to another creates no legal duty and makes no legal remedy available in case of non-performance. To be enforceable, the promise must be accompanied by some other factor. The question now to be discussed is, what is this other factor? What fact or facts must accompany a promise to make it enforceable at law?" And we have talked about the other 4 elements of contract formation. Now we come to consideration, which is the most complicated of them, and the one where there is a lot of case law as to what consideration can and can't be. There are some underlying threads which we will also talk about. But the question is going to be which agreements can be enforced and are therefore legal contracts, and which agreements cannot. Now, the agreements that can be enforced are those that contain the element of consideration. What is consideration? The mutual exchange of value. The rule is that promises will only be enforced if they form part of a bargain. Now, what is a bargain? It is a mutual exchange. It means the act or promise of one party bought or bargained for by the act or promise of the other. Each party exchanges something of value, and it has to be a mutual exchange. These have to be reciprocal undertakings. Now, that rule is the one that governs contracts, but there are 2 exceptions. First, the formal trappings within which the undertaking is given, and that simply refers to promises given under seal. It used to be that a promise given under seal was enforceable, and this is due to the formal manner in which the undertaking was given. And this usually involved the melting of some wax or substance and pressing an instrument on the substance to create an impression. Now, people now simply place their handwritten signature on the document and generally don't use seals. The other exception, which we will be talking about quite a bit, is promissory estoppel. Promissory estoppel is an exception to the bargain theory rule. It is a doctrine that prevents a person from retracting a promise that another person has relied on. So we'll get to that later. What is consideration? It is some right, interest, profit, or benefit accruing to the one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. Now, there's a lot in there. Let's break it down. Consideration must be provided by both parties. There has to be an exchange of value. A promise for which there is no consideration given is a gratuitous promise. It's a nudum pactum, a bare promise. Now, it has to be something given or promised in exchange for the promise sought to be enforced. The requirement of consideration will be met if I promise to give you a benefit or if I promise to suffer some sort of detriment. And that takes us to the second part. It has to be something of positive or negative value. So what's positive? Right, interest, benefit, or profit provided by the promisor. What's negative? Forbearance, detriment, loss of responsibility suffered by the promisee. And it has to be a concurrent exchange. It doesn't just have to be a concurrent exchange. Consideration must be exchanged for each other. So if it's a concurrent exchange, that's not enough. It has to be a detrimental action by the promisee in reliance on the promise, but not in return for it. So this is better explained under the Brantford case. Now, note, this case involves 2 gifts. First, the pledge, and second, the bequest and the will. Under the will, the hospital is the residual beneficiary. A residual beneficiary is simply a beneficiary that gets the residue in the will, what is left over after everybody has been paid. As a beneficiary under a will, you do not have to give anything in return for getting something under a will. So a will bequests some kind of benefit. Under a will, also, a debt always gets paid out first, before anybody else. So here, the hospital is claiming $800,000 owing to it under a contract, meaning the hospital is claiming that the $800,000 Mrs. Marquis was going to give it is a debt. What makes it a debt, says the hospital? Well, it's because she promised to do it under a contract. We had a contract for it. And if you have a contract, that means that you're obliged to do it. So the hospital is first claiming that the $800,000 that she promised is a debt, and meaning they will get that first. Second, they get the residue. So after the $800,000, after everyone else has been paid, the residue, they will get 1/5 of that residue. Now, before Mrs. Marquis did all of this, she had been identified as a, quote, lead donor, having inherited a lot of money from her husband. And the hospital CEO had talked to her several times about making the $1 million donation. She was presented with a formal proposal outlining the project and her requested involvement. And page 7 of the document asks Mrs. Marquis to consider making a 5-year pledge and goes on to state, quote, "We would very much like to name the unit after you and Jack, perhaps the Jack and Helmi Marquis Critical Care Unit." And a later letter both acknowledged and thanked Mrs. Marquis for her $1 million verbal pledge and stated that, quote, "With your consent, we would like to honor both you and Jack by dedicating our new combined ICU unit in a manner of your choice." So the court also found that it was irrelevant for Mrs. Marquis that her name be used in the new hospital wing. So it's those documents that the hospital is claiming form a contractual relationship between them. And so the issue was, is a pledge form signed by Mrs. Marquis in 98 a legal and binding contract, which is enforceable at law? Put another way, is it a promise enforceable at law or merely a nudum pactum? And the rule is that a promise to subscribe to a charity is not enforceable in the absence of a bargain. So how do you apply that to this case? Well, the court did find consideration in either the pledge itself or the circumstances. The court found Mrs. Marquis to be an incredibly generous person who had a lot of devotion to the institution, and the court even said that she intended to provide the foundation with this $1 million gift at the time of the pledge, in addition to her subsequent bequest. So the court found that she was going to do it. She had every intention to pay the $1 million. However, the court was unable to enforce her intentions in the absence of an enforceable binding contract. While the court would like to abide by the apparent wishes of the deceased, based on Canadian law as currently framed, it could not enforce the agreement. So it found consideration on the part of Mrs. Marquis, but it did not find any consideration on the part of the hospital. And Canadian courts have chosen to follow the English lead in this regard and require that consideration, however slight, be proven. Now, this is different than what the American courts have done. American courts appear more willing to consider enforcement of these promises, pledges to pay. So subscriptions of this nature are more enforceable under American law. So detrimental action by the promisee in reliance on the promise but not in return for it is not enough. So what if the hospital, let's go back a bit in the facts. The hospital, after Mrs. Marquis said that she's going to give this money, the hospital said, "We would very much like to name the unit after you and Jack." So what does that do? Well, that's the promise to name a building. the hospital says that's a little more than an expression of gratitude. That is the consideration. And the court said, no, that is not consideration. In fact, that is an expression of gratitude. And the question that arises from this always is, what if the hospital had done something in reliance on this money? So it had started to build a new care unit in reliance on this $1 million. And even then, detrimental action by the promisee in reliance on the promise, but not in return for it, is not enough. So here, the promise to dedicate a new unit to her was done after she had pledged the $1 million. It was not done in exchange for it. So why is that the case? Well, to hold otherwise would be to hold that a naked voluntary promise may be converted into a binding legal contract by the subsequent action of the promisee alone, without the consent, express or implied, of the promisor, which is why it cannot be concurrent only. It has to be in exchange for each other. In the next case, Lady Duff Gordon, the defendant was a fashion designer. She entered into an agreement with the plaintiff under which the plaintiff would have the exclusive right to market her designs and place her endorsement on the designs of others with her approval. In return, she was to have half of all the profits and revenues derived from any contract the plaintiff would make. The defendant was to have no right to endorse designs other than through the plaintiff's agency. And the plaintiff, what ended up happening in this case was that the defendant placed her endorsement on designs without the plaintiff knowing, and she withheld the profits. So the plaintiff sued her for damages. And here, it's clear that the defendant's consideration was being unable to promote her designs with others. But the problem arose as to what was the plaintiff's consideration. And the issue is, was there a contract? And to find one, we need to determine what the plaintiff provided for consideration. And in this case, the court found implied consideration, because without it, there would be no business efficacy to the agreement. Now, it did look at the agreement and found that it didn't place an explicit obligation on the plaintiff to promote the defendant's designs. So without that explicit obligation, did the agreement lack mutuality? But the court said that this agreement was instinct with obligation, imperfectly expressed. Meaning, although the agreement didn't specifically say that the plaintiff would use reasonable efforts to bring profits and revenues into existence, these terms are necessary to give business efficacy to the agreement. Remember, one of the requirements for implied terms in an agreement is that it would be absolutely necessary to give business efficacy to an agreement. And here, unless the plaintiff gave his efforts, he couldn't get anything, and neither would the plaintiff. So it found implied consideration. And what you see here is the beginning of courts being willing to escape from a rigid formalism. They said, the law has outgrown its primitive stage of formalism when the precise word was the sovereign talisman and every step fatal. It takes a broader view today. A promise may be lacking, and yet the whole writing may be, quote, instinct with obligation, imperfectly expressed. And as we go through the case law, you're going to notice the court taking a less rigid approach to the doctrine of consideration. And it continues today. Now, here, the court is likely not going to imply consideration if the party wishing to imply a term avoided assuming any responsibility under the agreement. So if he's trying to get out of the agreement by saying, I don't have to do anything, I didn't say that I would have to do anything under this agreement, the court is not going to imply something in his favor. So again, it's a matter of what the argument is. Another rule: consideration must flow from each party to the contract, but it doesn't necessarily need to flow to the other party. Now, I'm going to talk very briefly about the doctrine of privity, because we're going to talk about privity after the holidays. Privity, in short, is a doctrine that states that only parties to the contract can sue or be sued on the contract. This means that if a contract is made for the benefit of another person, the beneficiary, then the beneficiary would not be able to sue on the contract if she doesn't receive the benefit. Only the contracting parties can sue each other. So back to the rule, consideration must flow from each party of the contract, but it doesn't necessarily need to flow to the other party, meaning the consideration can flow to a third party beneficiary who's not a party to the contract. That is still valid consideration.